Hello, here we go again, and welcome to this webinar in our Shoosmiths series for in-house lawyers. My name is Sebastian Price. I'm a partner in the Shoosmiths Commercial Group, and I'm chairing today's webinar. I'm so glad you found the webinars in the first lockdown useful, and thank you very much for all the comments and feedback you gave us. And now, of course, another lockdown, if you're in England anyway, and a vaccine. But hey, enough of all of that. We found a way of working, haven't we? And we want to do our bit to help you. So it's more than just managing. It's about helping you thrive, helping you flourish. So the aim of these webinars is, well, firstly, to help people stay in touch. And if we can help you by putting in touch with one another, we're very, very happy to do that. But secondly, from a sort of doing the job point of view, it's to help you stay up to date with what you need to know, and so you're prepared for what's coming down the track in the legal world. And we're going to follow the same format, a half-hour bite-sized session with practical tips. Actually, in the case of this corporate insolvency, I'm beginning to regret the half-hour bit, because there's an awful lot to think about with the new Corporate Insolvency and Governance Act, which we'll just call SIGA for short. It's a significant piece of legislation, and there's more to it than is immediately obvious. And we've also had a lot of questions in, and we're going to try and answer as many as we can as we go along. But if we don't get to your question, then we'll try and answer them and get back to you in another way. So if you have questions during this session, please do use the Q&A function, and we will aim to answer them one way or another. So, corporate insolvency and the changes brought by the Corporate Insolvency and Governance Act 2020, SIGA. Now, as a commercial contracts lawyer, I'm thinking the main point of SIGA is that now you can't terminate a contract for a reason of insolvency. But Stuart and Julia, I'll introduce you in a minute, are going to tell us there's a lot more to it than just that. So anyway, we're in the scenario of one of the parties to a contract getting into financial difficulty and facing a possible insolvency process. So at this point, let me introduce Stuart Montgomery. He's a litigation partner specializing in the recovery of commercial debt and insolvency. So Stuart's going to start us off and give us an overview of the changes brought by SIGA as they relate to insolvency overall, to set the scene. And let me also introduce Julia Ishak. She's a legal director and specializes in commercial contracts and supply chain and risk management. So she will walk us through the new rules as they relate more specifically to contracting, and will give some practical guidance on the commercial considerations, which of course feed into the contract clauses you're going to need. And Julia, I know you've been doing a lot of work for clients recently dealing with that drafting. So anyway, Stuart, hi there, and perhaps you could just start us off with that overview of insolvency.
Yeah, morning everybody. Thank you, Seb. So what I'm going to do is I'll put in some context in terms of why these changes have been made. We've been asked a couple of questions about that before the session. I'll run through the changes in terms of the new moratorium, the new restructuring plan, and I'll also touch on changes to Crown preference. So a bit of background and a bit of context. The main changes to the insolvency regime took place in 2002 under the Enterprise Act. And that Enterprise Act brought into play the concept of a rescue culture. And I think if you think about the insolvency regime as being intended, if possible, to rescue a company rather than to punish it or to punish the directors, it does then put into some context the changes that are being made. The principal change in 2002 was the administration regime, which allows an administrator, an insolvency practitioner, to be appointed in order to administer the company and the prime objective of the administrator is to rescue the company as a going concern. So it's all about rescue. And once you sort of have that as a background, I think it explains these changes. So running through the changes then, the permanent changes under SEGA. First one, the new moratorium. Rather oddly, the new moratorium doesn't involve insolvency necessarily. The new moratorium can be put in place with or without any subsequent insolvency process. So I think we're all quite used to there being a moratorium preventing creditors taking certain actions when a company is insolvent. But here, a moratorium can be applied for by a company which is solvent. It applies to the court, and it can be granted an initial moratorium of 20 days, and that can be extended up to 40 days without creditor approval. So potentially the company can get a moratorium in place for 40 days, and you as a supplier of goods or services as a creditor will not be able to take any action against the company for that 40-day period. That can be extended up to 12 months, but that does require your consent as a creditor. So what does it do? Well, if the court approves it, an insolvency practitioner is appointed to oversee it as a monitor, and you as a creditor would be prevented from taking action against that company during the moratorium period. And what I mean by that is you can't commence legal process, you can't continue legal proceedings, you can't enforce a judgment, you can't crystallize your floating charge, and also you probably can't enforce security apart from some financial collateral contracts. So you as a creditor are sitting on your hands waiting for the moratorium to end. If you've got pre-existing debts, you can't do anything with those during the moratorium period, but what you can do if you are asked to supply goods and services during the moratorium in order that the company can continue to trade, in those circumstances you should be paid and you're entitled to be paid, and the company is also obliged to pay rent, wages, salaries and bank loans. So there are some things that the company has to do during the moratorium to keep trading. If you find yourself in a position where the moratorium has ended, you're still not paid for goods supplied during the moratorium, and if there's an insolvency process within 12 weeks, then you get what's called super priority status. In other words, if you've provided goods during the moratorium, allowed the company to trade to your detriment, then potentially you'll be paid in priority to some other classes of creditors in the eventual insolvency. But as I said, it doesn't necessarily mean that formal insolvency will follow. It might be that the company manages to sort its affairs out within that 40 days or 20 days. So that's the moratorium. Restructuring plan, I don't think we're going to see many of these, but I'll just very briefly discuss it. This is an update of the old scheme of arrangement. This is a Companies Act remedy. It's not an Insolvency Act remedy. Again, it's slightly odd. It's in the Corporate Insolvency and Restructuring Act. The old scheme of arrangement allowed a company to restructure itself or to do various things, not always involving an insolvent situation, and the restructuring plan does just the same. Under the scheme of arrangement, companies had some problems. If a class of creditors didn't agree, quite often the scheme of arrangement wasn't passed. The scheme of arrangement and the restructuring plan require creditor agreement and then court approval. The restructuring plan has changed things so that, in short, it's easier for the company to get through. And if creditors or a class of creditors don't approve it, the court can, in some circumstances, override that. As I say, I don't think we're going to see many of them. So in summary to those two changes, they've been made to allow companies breathing space, to allow them time, and potentially to be rescued and carry on trading. I said I'd mention Crown preference very briefly. This is something that's changed under the provisions of the Insolvency Act, although these changes have been brought in under the Finance Act 2020 and they don't commence until 1st December. In short, at present, income tax and VAT liabilities to Her Majesty's Revenue and Customs are treated as unsecured creditors in an insolvency situation. So they're right at the bottom of the queue in terms of who gets paid. At the moment, and until 1st of December, the only preferential creditors are employees. As from 1st December, those debts, HMRC debts for VAT and income tax, will move up the queue, as it were, and they will be preferential creditors again. So in terms of who gets paid first, it'll be fixed charge holders, i.e. security of London buildings, cost of the insolvency, then the preferential creditors. So HMRC gets paid along with employees ahead of floating charge realisations and ahead of unsecured creditors. So I would expect a significant increase in return in insolvency for Management Revenue and Customs, and I also expect going forward that you'll probably see a lot more bankruptcy and winding up petitions being presented by the Crown.
Right, Stuart, thank you very much. That's a great overview of where this legislation is coming from. But so now, Julia, over to you, really, and tell us something about the new rules aimed at protecting supplies of goods and services to an insolvent customer.
Thanks, Seb, and welcome everybody. So basically, as the Act, as the name suggests, the Corporate Insolvency and Governance Act, CIGA, is generally in relation to corporate insolvency and governance, unsurprisingly. There are, however, a handful of really interesting provisions that could fundamentally impact how suppliers think about their contracts moving forward. So basically, following CIGA, many suppliers may now find it considerably more difficult to terminate or suspend performance of its supply contracts and to exercise many other standard contractual rights based on its customers' insolvency, even if those rights are expressly set out in the contract. So broadly, these limited handful of provisions in relation to CIGA provide the protection of supplies of goods and services to contracts for the supply of goods and services, and that includes contracts entered into before CIGA, so it has retrospective effect, and applies where a customer becomes subject to a relevant insolvency procedure on or after the 26th of June this year. So this is live. This will now apply if and when your customers become subject to a relevant insolvency procedure. So basically, in this tiny little section of CIGA, it introduces 4 new rules. And so basically, where CIGA applies and where a customer becomes subject to a relevant insolvency procedure, the first rule is around no termination of the contract or supply. And under this rule, any provision in a contract providing for the contract or the supply to terminate or allowing a supplier to terminate the contract or supply because its customer becomes subject to a relevant insolvency procedure will cease to have effect. So that means moving forward, a supplier would not therefore be able to rely on any automatic termination or contractual right to terminate in those circumstances. The second new rule relates to no taking place or doing of any other thing, and this is deliberately widely drafted. And under this new rule, any provision in a contract providing for any other thing to take place or allowing a supplier to do any other thing because its customer becomes subject to a relevant insolvency procedure will also cease to have effect. Now, it's sometimes a bit more difficult to quantify what that actually might involve, but examples at this stage are likely to be changing payment terms, credit periods, payment tariffs, potentially exercising retention of title or variation rights, and increasing prices or requiring additional payments. The third new rule under CIGA on these particular provisions of CIGA relates to no termination for a prior event during a relevant insolvency procedure. So under this new rule, a supplier cannot exercise any contractual right to terminate the contract or supply because of a prior event if that right arises but was not exercised before its customer became subject to a relevant insolvency procedure. So in effect, this rule suspends the contractual right for the period of the relevant insolvency. And so under this, a supplier would still be able to avail itself of any right to terminate before a relevant insolvency procedure. So, for example, including any of the steps taken in the lead up to a formal relevant insolvency procedure. But this would now mean that a supplier would not be able to rely on a contractual right to terminate for a prior event once a relevant insolvency procedure begins. So, for example, if under your contract you're able to terminate before a relevant insolvency procedure for non-payment, you don't terminate for non-payment, your customer then falls into a relevant insolvency procedure, that right to terminate isn't extinguished, but it's effectively suspended. And then the final new right under these provisions in SEGA relate to no condition requiring outstanding charges to be paid. So under this new rule, a supplier cannot make it a condition or do anything which has the effect of making it a condition of any supply of goods and services after its customer becomes subject to a relevant insolvency procedure, that any outstanding charges in respect of a supply made prior to that time are paid. So in this situation, if you are owed significant amounts of money if your customer owes significant amounts of money to you, and they're then subject to an insolvency, you cannot insist on payment of that pre-insolvency debt as a condition of supplying moving forward. So in these circumstances, a supplier may therefore be obliged to continue to supply its insolvent customer even when it's owed substantial sums of money by that customer.
Julia, you're talking about contracts for goods and services, and I'm thinking, just tell us a little bit more about what those contracts could be, because I'm thinking, for example, software. There's always that thing: is it goods, is it services? What is it? So, tell us a little bit about the sorts of contracts we're talking about.
Of course, thanks, Seb. So unfortunately, SEGA was introduced in the midst of COVID and with COVID in mind. But it's not temporary. It introduces permanent protection. But unfortunately, because of its path to introduction, it was introduced incredibly quickly, and we have very little guidance. In practice, it's likely to be obvious which contracts are contracts for the supply of goods and services, and it's likely that SEGA is going to apply to most contracts for the supplies of goods and services, but there are a number of limited exclusions. Now, these exclusions tend to involve significant detail, which we don't have time to go in today, but it will involve, if you think these exclusions might apply to you, I'm afraid it'll involve a detailed analysis of whether you fall within these terms. But just to give you an idea of the exclusions we do know about, the first one is for essential supplies, and that broadly relates to gas, electricity and water, as you would expect, which may not be relevant to a lot of people tuning in today. But what it also relates to, which may be more relevant and includes essential supplies, is communication services and goods and services for the purpose of enabling or facilitating anything to be done by electronic means. And so that's likely to include computer hardware and software, information, advice and technical assistance, data storage and processing, and website hosting. Now, essential supplies may be governed by an existing separate regime. That's been in place for a fair amount of time and is quite considerably more limited than SEGA. So it may well be essential supplies are dealt with under that. However, where that separate regime doesn't apply, SEGA is a default position and may still apply to essential services. There's also some exclusions for persons involved in financial services and contracts involving financial services. There's also exclusions for specified legislation, so the examples are financial markets and aircraft equipment, and there is a temporary exemption for certain small suppliers. That was originally due to expire at the end of September this year. It's now been extended to the 31st of March next year, and it's uncertain whether that might be further extended, but that's where it currently is in place. And then, Seb, going back to your specific query, as I say, whilst this is unclear and will be a question of fact in all of the circumstances in each case, there is a suggestion that SEGA may also apply to agreements that are not usually regarded as contracts for the supplies of goods and services. So that may include, exactly as you say, Seb, software licenses. It may also include intellectual property licenses, but additional agreements that may be covered by SEGA may also include equipment hire, franchise, agency and distribution arrangements. Similarly, the guidance note suggests that while certain contracts, and the examples they give are licenses, property leases, agreements for the sale of land and property, are not going to be regarded as contracts for the supply of goods and services, there is a suggestion that certain substantial contracts of that nature may contain an element of supply of goods and services. And the commentary suggests, the guidance note suggests, that that element of supply of goods and services may actually be caught by SEGA. So I think it's beware when you're thinking of SEGA, beware of the kinds of contracts and whether there's actually an element of supply of goods and services that might actually be caught.
Thanks. So another follow-up question I got, which before we move on to practical tips, Julia, which I know we need to get from you, is and Stuart, I think this is a question for you. We're saying relevant insolvency procedure. Just give us a bit of guidance on what that means, and in particular, how easy will it be to know that has happened?
Again, I don't think it will be easy to know. The easy place to look to try and work out what's happening with the company is, of course, Companies House. But because these procedures happen fairly quickly, so for example, when we appoint administrators, we can do so on the afternoon. We do it very quickly. Companies House inevitably can't keep up, and so you won't be able to see from Companies House as to precisely what the insolvent status of a company is. It takes a week or so for that to appear. You will be reliant upon the company telling you or the insolvency practitioner. So, for example, if a company is in administration, you would expect that the administrator would write to you and inform you, particularly if you're a major creditor. If you're looking at the moratorium and the restructuring plan, well, you're going to have notice at some point because you're going to have to potentially vote on it, or you might be asked to vote on the restructuring plan, for example. But no, that's a concern. You could be merrily providing goods and services without knowing that you're in a moratorium situation or that the company's in an insolvency situation.
Yeah. Okay, right, thanks, Walter. Now, Julia, back to you. What should IHLs be thinking about to protect the business?
So in terms of drafting considerations to help protect a supplier as a result of SEGA, there's a number of things we can now be thinking about. So the first and foremost is, how do we deal with clauses that may well cease to have an effect as a result of SEGA? We've gone through the 4 new rules, and there are now many standard contract clauses that as a result of those rules may cease to be effective following SEGA. However, unfortunately, at the point that you are drafting the contract, it may not be clear whether SEGA will or will not apply, and it is likely to depend on the individual circumstances of each case at the point in time a supplier seeks to rely on that provision. It's also not unlawful to include these provisions, and they may actually be useful to retain. So suppliers moving forward, and IHL's advising suppliers, now have a choice. They can delete all the provisions that may cease to have an effect following SEGA, or actually retain these provisions but treat them with caution before relying on them. And my recommendation would be, and obviously this is a broad overview, but I would generally recommend considering retaining these provisions even though they may cease to have an effect following SEGA. But that is going to depend on the individual circumstances of each contract and will need to be assessed on a case-by-case basis. And this approach isn't without risk to a supplier. And what suppliers need to be very careful of is if a supplier seeks to rely on a provision in the contract, and that provision is expressly set out in the contract, but because of SEGA it ceases to have effect, a supplier relying on that could actually find itself in breach of contract and, for example, liable for wrongful termination or damages. So I think it's absolutely vital, if that approach is adopted and these clauses are retained within a contract, that actually suppliers should consider legal advice before relying on or exercising any rights where a customer is in financial distress. So that kind of deals with the standard clauses that we know might be a problem as a result of SEGA. But in addition to that, there might be additional clauses and amendments to consider including as a result of SEGA to try and mitigate some of the additional risk for suppliers now following the introduction of these protections. So key clauses around that additional protection is likely to be, for example, termination. So typically you'll have clauses in contracts that allow for termination of insolvency events. It's now worth considering whether they should be expanded so that suppliers can now terminate for pre-insolvency events. So, for example, if a supplier starts to become concerned about the financial stability of its customer, there may be remedies in the lead up to a customer actually becoming subject to a formal insolvency procedure. You've also got slightly more difficult quantifiable termination rights, but start thinking about termination if a supplier reasonably believes an insolvency or pre-insolvency event is about to occur, or if they believe a customer's financial position is deteriorating so much that that's likely to impact a customer's ability to fulfill its contractual obligations. All of these are trying to bump forward the time that a supplier may be able to terminate. But of course, as Stuart was saying, quite often these kinds of provisions may be very, very difficult to actually know when these are happening. So I think in relation to drafting post-SIGA, it's about getting a whole series of additional rights to protect a supplier. There's also, think about some of the more traditional rights that may or may not currently be in the contracts. So for example, termination for convenience. That might suddenly become even more appropriate in a post-SIGA world. Think about termination for non-insolvency related events. So are there any practical situations that could occur that are going to cause a supplier problem, and actually they could be specified as a termination event? Also think about termination for non-payment and shorter notice periods for termination. The overriding message in relation to SIGA is you may need to act very quickly, because if you don't act quickly and in the right time, you may find your rights are suspended once your customer becomes subject to a relevant insolvency procedure. Similar provisions around suspension of supplies. So whilst suspension of supplies may be more problematic once a customer has become subject to a relevant insolvency procedure, start thinking about whether for pre-insolvency events you might want to think about suspending supplies or for non-payment. So it may not stop you ultimately having to supply you're an insolvent customer, but it might reduce the amount of supplies you've had to give to them and not be paid for. Retention of title is obviously potentially a significant clause. Often retention of title are triggered by insolvency events, and that's going to be much more problematic in a post-SIGA world. But think about the trigger points within retention of title. Should the rights under retention of title also be triggered for pre-insolvency events, where you have a concern about your customer's financial position? Should they actually be triggered? And should you be able to get back the goods at any point before title has passed? I suspect commercially that will give suppliers most protection, but could be really contentious and may not be workable in practice. Then to support
Julia, sorry, let me just jump in, because I can sort of feel that we're probably just going to go beyond 11 o'clock, which I apologise for. But so obviously if people have got to drop off, then do so. But I think Julia's got some useful stuff here, so we will just carry on, and hopefully it won't be too much afterwards. Sorry, Julia, please carry on.
No problem. Thanks, Seb. I shouldn't be too much longer. From a reporting point of view, so for a lot of the reasons that Stuart was saying around you may not know your customer is subject to an insolvency or taking steps in pre-insolvency, start thinking about now whether there should be an obligation on your customers to notify a supplier immediately any steps are taken or threatened with a view to a pre-insolvency or insolvency event. Also think about whether you'd like your customers to start providing regular financial information and whether they should be asked to attend meetings on financial status. And think about, if you do put those rights and remedies in, what should happen if you're starting to get concerned about the financial status of your customer. Payment is also another area where I think post-SIGA we're going to see tightening of provisions. So think about where your payment structures may be able to be tightened. Is payment or part payment in advance appropriate? Think about payments by instalment, reducing payment periods and reducing periods for remedying non-payment, because again, time is going to be really critical. If you are having to wait for a period to elapse and in the meantime your customer enters a formal insolvency procedure, you may not have the rights and remedies you were hoping for. Think about payments being due immediately and payable on termination. Traditionally, they were triggered by an insolvency event. That's going to be problematic following SEGA. So think about whether there are any other appropriate triggers, whether that's non-payment or termination. Think about, and these are the slightly wider implications that are going to apply on a contract-by-contract basis following SEGA. It may apply to a lot of other areas that aren't immediately apparent. So, for example, if you're paying your customer retrospective rebates, where they buy a certain amount of volume from you, you might not want to be paying those rebates if they have bought but not paid for those goods. So think about how those payment structures may work. And then from a self-help remedy point of view in the contract, you might want to think about how you're structuring your credit accounts, whether you want to be asking for letters of credit, parent company guarantees, performance bonds, payment guarantees. I know they can be difficult, but it might be worth sitting and thinking whether they may be helpful in these situations. And you might also want to be thinking about structuring your contracts. So if you structure your contracts as a series of separate contracts that a supplier is free to decline, it won't stop you being in trouble by orders that are already accepted, but it might stop exacerbating and growing the problem if you can decline future orders. Think also, we've talked about suitable alternative trigger events rather than insolvency procedures. Think about, and this might not be commercially acceptable, but shorter contract terms, reducing contract volume, and ability to refuse to renew existing contracts, or giving your supplier a get out if a customer is in formal insolvency procedures. And then depending on the approach you adopt in relation to all of the clauses that we've been talking about, you might need to enhance protections in a series of supporting clauses. So start thinking about set-off. Start thinking about severance. I don't like the idea of recommending that you include clauses in your contract that you don't think might be enforceable, but for all the reasons that we've talked about, that is probably a sensible approach to consider. If you do that, you might want to make sure you've got robust severance provisions. So if that provision is deemed to be ineffective following SEGA, you have the ability to continue with the rest of the contract, and that clause doesn't bring down the entirety of the clause or the entirety of the contract. For similar kinds of rationale, think about waiver. By talking to your customers, are you waiving any rights? You might want to have enhanced rights so that you are not waiving any of your existing rights, and that all of your rights and remedies are cumulative and in addition to any other rights and remedies you may have. There is also a lot of the additional protections you might want to think about as a result of SEGA. They are likely to include a contractual discretion. So, for example, a discretion to accept or decline a new order, a discretion to change prices, a discretion to suspend. With that exercise of a discretion, there is a potential for a duty of rationality. This is an implied obligation, and it can be implied into contracts in the absence of clear language to the contrary. And basically, this is an implied obligation to exercise a contractual discretion in good faith and not arbitrarily or capriciously. Now, that can be extremely difficult to exclude, but it's not impossible, and you need to start be thinking about that. And then very quickly and finally, and apologies for the overrun, practical things to be thinking about as a supplier as a result of SEGA. So what should suppliers be doing now? Well, it goes without saying for everything that we've discussed, reviewing existing contracts, amending standard form templates, addressing SEGA in future contract negotiations, particularly where it's your customer contract that you're discussing, because these protections are unlikely to be in there. However, as a note of caution, even the best drafted contract is not going to be able to protect suppliers from the full impact of the new protections that we've been talking about under SEGA. So it's also really important for suppliers at this stage to carefully consider what additional practical steps, self-help remedies and contract procedures may be appropriate to help support a supplier through the maze of the new rules. And examples of this include reviewing your approach to managing contracts and mitigating insolvency risk. Think about whether enhanced contract management procedures might be appropriate. consider possibly greater due diligence on customers pre-contract and greater due diligence throughout the lifetime of the contract where those contracts or customers are significant. Think about whether training for contract managers might be appropriate so they know what they should and shouldn't be doing as soon as their customer starts to show signs of financial distress. I think a good working knowledge of material customer contracts is going to be absolutely critical, so the business is familiar with its rights and how to exercise them and the timescales to exercise them if your customer starts to show signs of financial distress. And I think it's all we've talked about, timing may be absolutely critical. It's about being prepared to promptly exercise contractual rights where that's appropriate for the business. Also think about actively monitoring customers' payment and performance and financial position, ensuring invoices are paid, tightening debt collection procedure, and then there's also reviewing insurance cover and whether insurance finance options and trade credit insurance might be relevant.
Julia, thank you very much. Apologies, everybody, we are over time. I'm really sorry about that. But listen, I know Stuart and Julia would be more than happy if you've got any questions that come out of this, or you just want to have a chat with them, anything that's particular to you, please do. They'll be more than happy to do that. So thank you, Julia. Thank you, Stuart, and thank you, everybody, for joining us. Lovely to be on with you, and see you soon. We've got one coming up at the beginning of December on arbitration. Should you use it? Arbitration or litigation? But anyway, bye for now.
Thanks all.
Thank you.